So, hi everyone, welcome to the class of the Indian Contract Act. So, under section 14 of the Indian Contract Act, we have already understood the basic requirements of the contract, like under what circumstances or what conditions the contract becomes void or contract becomes voidable in nature. Okay, so we have understood there are certain conditions like if there is the lack of the free consent from the both of the parties, then that makes the contract voidable in nature. So what are the conditions which makes the contract out of free consent? Got it? So under those conditions, you have understood there are the five situations under which if the contractual agreement has been signed, then the contract or the agreement becomes void or voidable in nature. So what are those we have understood? First, we have understood the coercion. The second, we have understood the undue influence. Third, we have understood that is the fraud. And fourth is misrepresentation. And fifth is the mistake. So when coming to the part of the coercion under section 15, we have already understood what is the nature of the coercion and how the coercion actually happens. Coercion means the unlawfully forcing someone to do certain kind of act or by the way of threatening someone to do certain kind of the act. For example, it might be by the person or towards the property. I mean, the threatening towards the particular person can be done by the person whom he or she knows, or certain kind of threatening to harm that particular person or to harm the property of the person. So the act of the threatening is usually called as the coercion. Basically, we have already understood under this, like any kind of illegal activity which is considered as a crime under the Indian Penal Code. If any of the party is insisting or threatening another party by doing any certain kind of act which has the penal nature or which is criminal in nature, or threatening to do certain kind of act to the another party which act is criminal of nature or harmful in nature, so by the activity of the threatening doing that particular act is called as the act of the coercion. Got it? So when you have studied about the activity of the coercion, then under that we have studied two things: the coercion towards the property and coercion towards the person. And the act which is done by the activity of the coercion, the act must be unlawful in nature, just like the act of the kidnapping, the act of forcing someone, abandoning someone in a particular region, or else like doing any certain kind of activity which is illegal in nature, which is like criminal, which has the criminal nature. Got it? So that kind of activity you call as the coercion. If, for example, I am having a daughter who is having the 5 years of the old. My daughter used to go to school by the taxi or by the bus, or goes and regularly travels to the school. So someone is threatening me that if you are not entering into the contract or if you are not signing the agreement, then I am going to kill your daughter or I am going to kidnap your daughter. So with the fear that there might be any harm to my daughter, what I did, I entered into the agreement or I signed the contract. So here the consent I have given for that particular contract, that is not considered as the free consent because that consent has been given under the force or under the influence or under the coercion. That we have understood. A second condition we have understood like the property. For example, I am having a house in the another location or another state. Then you are threatening me that if you are not signing the contract right now, then I am going to burn your house. Or I am going to do certain kind of harm to your land or to your property. So in that fear of any, like, I'm having a fear in my mind that if I'm not signing in the contract, then there might be some harm to my property or to the person who is close to me. So in that fear, when I am entering into the agreement or entering into the contract, that contract is not considered by the valid consent, or that consent on behalf of the me is not considered as the free consent in nature. Then we have understood about the undue influence, where we have already understood where one party is at the dominant position from the another party. For example, you are my father, you are my mother, you are my relative, you are my boss, I'm your employee. So I am having at a inferior position than you, and you are having a superior or dominant position than me. And at that point of time, you are forcing me, you are insisting me to do certain kind of work which is harmful to me but beneficial to you. Got it? So when this activity actually happens, then what happens? Then in that uh, course of that activity, when I am influencing you this, do that, then with the influence, you went and you did that act. So in this kind of influence, which is done with the intention to harm certain person or to get wrongful benefit from a particular person, that is called the undue influence, where one party is at the dominant position from the another party. मान लीजिए, I am your boss in the office. You are my employee, you are my staff. So what I am doing, I am insisting you that just make your home with my name. आपका ये वाला जो घर है ना, वो मेरे नाम पे कर दीजिए, and then I am going to give you a good salary hike or promotion. So this kind of activity where I am influencing you for my wrongful benefit to do certain kind of wrongful act is called the undue influencing nature. Got it? Then come to the point of the fraud. Okay. Fraud means the intentional wrongful activity. That is an activity where you actually know, आपको अच्छी तरह से पता होता है कि the act you are doing, that is not valid in nature, that is not a rightful act, but even after knowing that, you still step up to do that particular act with the intention of the wrongful benefit, and that is what you call as the fraudulent activity. Got it? So when we're talking about the fraudulent activity, then it has having certain nature, like to active concealment of the fact, like and the second, the promise or the any promise to be which need to be performed, but you are making that promise without the intention of performing that promise. So this kind of activity is considered as the fraud. For example, I am promising you that if you are giving me that, if you are selling me your land, then in return I am going to pay you 5 lakh of the rupees. So here is the promise on my behalf or on from my side that I am going to pay you 5 lakh of the rupees in return of your land. In your, if you are selling your land, so in return as the consideration, I promise that I will pay you 5 lakh of the rupees. So, but when I'm doing that promise now, I am thinking in my mind, no, I am not going to pay that person that 5 lakh rupees. I'm going to do a fraud with that person after taking the ownership of the property, ownership of the land with on my name. I'm going to escape. Okay, I'm not going to pay that person any single penny, or I'm going to pay that person just 2 lakh of the rupees. Rest 3 lakh I won't pay that person, and I will matlab, ditch it or ditch that person. So in these cases, when you are promising something, but in your mind you have already decided not to perform that particular promise, then the promise is called as the activity of the fraud. And secondly, the condition that is told the active concealment of the fact. That means you know certain kind of fact which need to be disclosed to the another party, but you are knowingly hiding the fact from the another party. For example, you are selling your horse to another person. आपके पास एक घोड़ा है, आप वो घोड़ा दूसरे इंसान को बेच रहे and you know the horse is having certain kind of the disease or the horse is having the mental instability sometimes. जो कि जो बंदा वो घोड़े को खरीद रहा है उसको बताना that is the duty of the seller to let know the buyer about the defect of the product he is selling. आप जो चीज बेच रहे हो उसका क्या डिफेक्ट है, उसका क्या कमी है, उसको बताना आपका फर्ज है. But what you are doing, you are not informing the another party that yes, this is the horse, and if you are taking it, if you are buying it, then buy. I don't have any issues, but just remember that this horse is having certain kind of sickness, and you need to take care of that horse by the proper treatment. So you are hiding that fact from me with a fear कि अगर आप बता दोगे तो शायद मैं आपका घोड़ा ना. तो इसलिए मैं जब आपको पूछती हूँ that is the horse is active on a working condition, then you are telling me that yes, the horse is at very active position, horse is at very smart, there is no defect inside the horse, but in real the horse is sick. So after buying that horse, I got to know about the sickness of the horse. So when I am discovering the fact that the horse is sick after buying that particular horse, but you have not informed me that before selling it, then this act is called as the fraudulent activity for the active concealment of a fact. यहाँ पे you have hide me something, you have concealed certain kind of fact from me that is illegal in nature, क्योंकि आप मेरे को बिना बताए कोई भी डिफेक्टिव चीज मेरे को नहीं बेच सकते. Got it? So here the activity of the fraud has been listed. Then we have understood about the misrepresentation. Yes, and under misrepresentation is very easy concept जहाँ पे हमने समझा था कि मेरे को लगता है कि मान लीजिए आई एम वर्किंग एज ए प्रोफेसर इन ए कॉलेज एंड आई हैव बीन got informed wrongfully या फिर certain kind of miscommunication has been happened with me with the college authorities, and I thought that your final semester is getting resumed from 5th of the next month, 5th of the August. Okay, so when you guys are asking me that when is our final semester is going to happen, I'm telling you that guys, your final semester is going to happen from 5th of the August. Got it? So when I am expressing that, guys, your final semester is going to happen from 5th of the August, then it is pretty clear that I didn't have any intention to tell you any kind of the lie or to do any certain harm to you, right? मैं यहाँ पे आपको जो बोला कि 5 होने वाला है, मेरे को भी वही यकीन है कि हाँ 5 अगस्त को ही एग्जाम शुरू हो रहा है. मुझे पता नहीं है कि एक्चुअल स्टार्टिंग ऑफ डेट ऑफ द एग्जाम इज नॉट 5th, इज 3rd अगस्त को एग्जाम शुरू हो रहा है, 5th अगस्त को नहीं शुरू हो रहा है. बट यहाँ पे मेरा ये ऑनेस्ट बिलीव है, मेरा ये गुड फेथ है कि नहीं एग्जाम 5 को ही शुरू हो रहा है. तो दिस इज द कॉन्सेप्ट ऑफ द मिसरिप्रेजेंटेशन, जो कि मैं कोई पर्टिकुलर फैक्ट को कोई पर्टिकुलर कॉन्सेप्ट को आपके सामने मिसरिप्रेजेंट कर रही हूँ, गलत तरीके से प्रेजेंट इंफॉर्मेशन दे रही हूँ, बट मेरे को खुद को नहीं पता कि मैं गलत बोल रही हूँ. आई बिलीव दैट मिस्टेक और दैट wrongful thing as the true. Got it? So next, voidability of the agreement without free consent, and we have under this we have understood there the agreement which is caused by the coercion, fraud or misrepresentation. Then in those cases the agreement is called as voidable in nature without the free consent. What are those? First is coercion, second is fraud, and third is misrepresentation. We just discussed all these factors. So when there is the presence of the coercion, fraud, or misrepresentation, then the contract becomes voidable in nature. Got it? So what do we understand by the voidable in nature? That means it is the complete discretion of the parties to continue with the contract or to end the contract. Got it? So this is completely upon the another party who has been suffered due to the act of the coercion, fraud or misrepresentation. The act of the coercion, fraud और misrepresentation के द्वारा जिस भी पार्टी ने नुकसान जिस भी पार्टी को नुकसान पहुंचाया गया है, the party who has been suffered, it is the complete decision of that party to decide that he or she wants to continue further with that particular contract or want to end the contract. Clear? Then we have understood section 19A, where we have already studied the power to set aside the contract which has been done by the undue influence. So if any kind of the agreement has been done by the undue influence, if the act of the undue influence has been proved, then the contract, this is the discrimination of the party. This is the discretion of the party to decide that the party wants to continue with the contract or not. Got it? And the second thing we have studied that where both the parties to an agreement is caused by the undue influence, then the agreement of the contract is voidable at the option of the party whose consent has been so caused, and the party has the right to set aside the contract. What do you understand by the setting aside of the contract? Setting aside of the contract means to avoid a particular contract. Got it? For example, there is a contract that is existing. You are avoiding that contract. You are terminating that contract at a certain period of time. That is called the setting aside of the contract. Clear? Just 1 second, guys. I am getting a call. 1 minute. No, got a call. Okay. So, section 20, it speaks that the agreement is void where both the parties under mistake as to the matter of the fact. Okay. So, the contract or the agreement becomes void when both the parties are under the mistake of the matter of the fact. Okay. So under the 5 conditions we have studied in section 14, the last condition we have studied, that is the mistake. Got it? So when we are talking about the mistake, then we know that the agreement of both the parties are void where there is the presence of the mistake of the fact. So when we are talking about the mistake, that how many kinds of mistake that actually exist? There are actually 2 kinds of the mistake that exist. That first one is mistake of the fact, and the second one is the mistake of the law. Got it? So when we are talking about the mistake of the fact, that means the factual mistake where both the parties are misunderstanding at a certain point of time. For example, as we have understood in the last class, I am insisting you that I am requesting you, कि ma'am, please take the class, okay? So you are telling me that yes ma'am, I am ready to take the class, but I will take the class at 8. Okay? So here you think I will take the class at 8 a.m. But in my mind, when I am telling you that yes, I want to take the class, but it will be at 8. In my mind, it is as of 8 p.m. Got it? So here is the presence of the misunderstanding between both of us. And here the most important thing that is here, that is the mistake of fact. यहाँ पे there is the actual mistake has been happened. There is no transparency, no clarification of the concept that when exactly I am going to take the class. Got it? You are thinking that ma'am is going to take the class at 8 a.m. and I am thinking that I am going to take the class at 4 p.m. You are thinking I told that I will be taking the class at 8. You have thought that the class will be at 8 a.m. But here in my mind, I have told that I want to take the class at 8 p.m. So here there is the factual misunderstanding between you and me. You are thinking something in your mind, but I am thinking something else in my mind. Here there is the मिसकम्युनिकेशन मिसरिप्रेजेंटेशन आप एक तरीके से समझ रहे हो मैं एक तरीके से बोल रही हूँ सो हियर देयर इज नो सेम थिंग एज ए सेम सेंस इज प्रेजेंट ओवर हियर हम दोनों जिस चीज को लेकर एग्रीमेंट पे एंट्री कर रहे हैं या फिर कॉन्ट्रैक्ट में एंटर कर रहे हैं द पॉइंट ऑफ व्यू ऑफ बोथ ऑफ अस इज टोटली डिफरेंट सो हियर in this kind of the contract is called as a the contract is called as a voidable in nature when there is the presence of the matter of the fact. So it is the discretion of the party to decide that the party wants to continue with the contract or to end the contract. Got it? So under yeah, and one more thing, if there is any kind of impossibility of the performance, then the nature got it. So let's understand section 20 of the Indian Contract Act. Let's read it out. Where both the parties to an agreement are under a mistake to a matter of the fact essential to the agreement and then the agreement is got it. Then the exception says our erroneous opinion as the value of the thing which forms the subject matter of the agreement is not to be deemed a mistake as to a matter of the fact. Okay, actually there is heavy rain over here, so that is why continuously there is the network breach and I am getting disconnected automatically. So it took me some time to reconnect and come back. Yeah. So we are talking about the mistake as to the matter of fact, and we have already understood when we are talking about the mistake of the fact, that is of two types. First is the mistake of the fact, and second is the mistake of the law. And we have already understood where there is the mistake of the fact, where there is the miscommunication between the parties. In those cases, the contract becomes void in nature. Got it? Let's take an exception illustration regarding to that. A agrees to buy from B a certain house. It turns out that the horse was dead at the time of the neither party was aware of the fact. The agreement is void. Okay. What did you understood? We have understood the mistake of the fact by the both of the parties. I have given you an example of the class time. The store I'll be taking the class at 8 a.m. and I told that night time it has not been confirmed by the anyone. So this kind of the contract between both of us is totally nature. So the second point, the second illustration we can talk about. For example, A is selling certain kind of the horse. मेरे पास एक घोड़ा है, घोड़ा मैं बेचना चाहती हूँ. So when I have decided someone, yes, you are the person you want to buy my horse and I am ready to sell your horse. But while we were going to do that agreement of the sale deed of that horse, okay, on the way, the horse died. उस घोड़े का मौत हो जाता है due to certain reasons. जो कि ना आपको पता है ना मुझे पता लग रहा है कि हाँ मेरा घोड़ा मैं उसको अभी बेचने ले जा रही हूँ आपको पता है कि हाँ वो मैंने अभी खरीदने जा रही हूँ बट यहाँ पे द हॉर्स हैज बीन एक्चुअली डाइड तो अगर कोई चीज जिंदा है ही नहीं इफ द हॉर्स इज नॉट इवन एग्जिस्टिंग उसी का मौत हो चुका है देन हाउ डू यू कंसिडर दैट द एग्रीमेंट विल बी वैलिड एग्रीमेंट कैसे वैलिड हो सकता है एग्रीमेंट विल बी कंप्लीटली एंड टोटली void in nature. Got it? And under section 21, we have understood about the effect of the mistake of the law. We have already understood about the mistake of the fact, and now we will be understood about the mistake of the law. Under the mistake of the law, it has been told that a contract is not voidable because it was caused by a mistake as to any law in force in India, but a mistake as to a law not in force in India has the same effect as a mistake of fact. Okay? यहाँ पे क्या बोला जाता है? A contract is not voidable because it was caused by a mistake of any law in force in India. कोई भी इंडियन लॉ जो कि ऑलरेडी कंटिन्यू इन इंडिया, अगर एग्रीमेंट के टाइम या कॉन्ट्रेक्चुअल डॉक्यूमेंट साइन करने के टाइम इफ देयर इज एनी मिस्टेक ऑफ लॉ, जहां पे लॉ का मिस्टेक नहीं रहना चाहिए, एंड if there is any kind of the mistake in the law, in the Indian laws, then for that reason, the contract is not going to be void in nature, but it is voidable in nature. Got it? The second illustration, it speaks that debt is bad by Indian Law Commission and the contract is not voidable. Okay? What did it exactly speak? The debt is backed by the Indian law of limitation. Then the contract is not voidable in nature. Okay. And where the A and B are entering into a contract on the anonymous belief that this law is actually existing. This law is already on force. This law is already continuing. And on that belief, A and B are entering into a certain kind of the contract. In that cases, the contract is not going to invalid in nature just because it has been registered under a law which is not implicable or applicable in India still now. Got it? So, under Section 22, it has been spoken that contract caused by mistake of one party as to the matter of the fact. It speaks about the contract is not voidable because it was caused by one parties to being under a mistake or as to a matter of the fact. That means when a contract is done as the mistake of the fact by the parties, okay, or by the one party and not to the another party, then the contract is not voidable in nature. Okay. In the first circumstances, we have understood under the mistake of the fact under section 21 that there must be both the parties are mistaking upon a particular fact. दोनों पार्टी एक फैक्ट को लेके एक मिस्टेक ऑफ फैक्ट में अगर कंफ्यूज हो रहे हैं, if there is any kind of the conflict in the mistake fact, but if there is no particular clarification as per se, or both the parties are totally unaware about the original fact. Got it? So in that case, the contract as the unlawful or void agreement in nature. Got it? But the second point we have understood that when there is the lack of the mistake of law, that means you and me are entering into a contract believing that the thing or the clause which is implicable in the Indian Contract Act or under which we are doing the agreement, that is still enforceable under the court of law. And we are just doing an agreement or entering into the contract with that particular belief. So here, that is why even if the contract is not happening, even if there is the lack of the contract over here, then the party who is at the mistake of the law, that is the discretion of the parties to continue the contract, and it does not consider that the contract will be void or voidable in nature just because the party was on contract. So when we have already understood what consideration and objects are lawful and what consideration and subjects are unlawful in nature. Okay. So when we're talking about the legality of the parties, like what makes the parties lawful or what makes the parties unlawful, then we have understood that when something is forbidden by the law, any kind of the contract, any kind of agreement which is forbidden, accessed, or protected by the law. The secondly, of any of such nature that if permitted, it would defeat the provisions of the law in nature. The third point we have always understood the person and property of another, or implies injury to the person or property of another. And the last one, the court regards it as an immoral or of the public policy. When any kind of the contract or agreement is opposed to the public policy, then the contract or agreement is considered as void in nature. Okay. If the contract is following these kind of the conditions, then it will be considered as lawful. And except this, any kind of the situation, any kind of the mistake of law, any kind of the mistake of fact is present in the contract, then the contract or agreement will be considered as valid in nature. So what are those conditions? The first is the contract is forbidden by the law. The contract does not have any legal applicability. The parties are not competent to contract, or the product is defective, or actual nature, or their particular nature. The second point, it would defeat the provisions of the law fraudulent. The contract has been done with the fraudulent activity and it is defeating the provisions of the law. It is not following the provision of the law. Third, it causes injury to the another party or person. The contract is being done with the intention to provide injury to the another party or another person. The next point, when it is immoral to the public policy, when it is violating the public policy, when it is violating the public peace and public tranquility. And in these cases, if there is any kind of contract is there, the contract will be considered as invalid or void. If that is hampering the public policy, making with the fraudulent condition to do harm to the another party, causing injury to the another person, prohibited by the court of law or prohibited by any law in India. Got it? In these conditions, if there is any kind of contract is present, agreement is present, that contract or agreement is considered as void in. So this is about